judges of the Supreme and District Courts, judges of the Federal Court, Chief Magistrate Ronaldo, retired judges, distinguished academics, members of the profession, ladies and gentlemen. I should say too that there are many apologies tonight, including from the Governor, the South African High Commissioner, the Chief Judge, the Commonwealth Attorney General, and many others, all of whom I have no doubt deeply regret that they won't have the opportunity to hear from such a distinguished jurist with such an extraordinary background. Justice Moseneke retired from his position as Deputy Chief Justice of the Constitutional Court of South Africa 2 weeks ago, so he's still feeling that first glow, I think. He's always had a deep interest in legal education, and he remains Chancellor of the University of Witwatersrand. His story is a remarkable one, and I want to tell you some of it so that you will understand that when he speaks from his position as a former Constitutional Court judge, he's not doing it from the metaphorical ivory tower, which the press like quite unfairly to attribute to judges. He's been a fighter for rights since he wasn't much more than a child. At 14, he became an anti-apartheid activist, joining the Pan-Africanist Congress, which was a banned organisation. He was arrested the following year at the age of 15 and dealt with on a charge of sabotage without the benefit of legal representation. He spent the next 10 years as a prisoner on Robben Island. It's hard to imagine that loss of youth between the ages of 15 and 25 as a prisoner. Nelson Mandela became a mentor there. While imprisoned, he undertook his matriculation and 2 university degrees. After his release, he completed a Bachelor of Laws. But he then had to fight to enter the legal profession. The Law Society opposed his admission because of his conviction. The court, having decided that he was a fit and proper person, he began his practice as an attorney in 1978. And after 5 years he went to the bar. He had difficulty as a black man getting pupillage in Pretoria, so he went to Johannesburg. Pretoria having had a whites-only membership rule. He returned to practice as a barrister in Pretoria. In the course of his practice, he defended activists and unionists. After 10 years, he became senior counsel. He received letters patent signed by F.W. de Klerk at a time when he actually had no right to vote. He'd remained active in the Pan-Africanist Congress and became its deputy president when it was no longer banned in 1990. The expression is unbanned. He served on the committee that drafted the interim constitution. He was deputy chairperson of the Independent Electoral Commission, which conducted the first democratic elections in South Africa. I should say that when we talked before coming down, he said that Mandela always seemed to put such confidence in him to be able to do things. But when you look at his history, there was nothing that he couldn't do. His career took a side turn for 5 years from 1995 when he went into the business world, becoming, among other things, the chairman of Telkom, the South African telecommunications provider. In 2001, he was appointed to the High Court and a year later to the Constitutional Court. In 2005, becoming Deputy Chief Justice. He was for a period acting Chief Justice. There is certainly a view that the fierce independence of his decisions on the Constitutional Court may have had something to do with his role being confined to an acting one. For example, in Mazibuko and Sisulu, the applicant was the leader of the opposition who sought to move a motion of no confidence in the president, and the respondent was the Speaker of the National Assembly, who relied on the fact that the parliamentary rules contained no provision for a vote of no confidence. Justice Moseneke wrote the judgment, in which 5 other members of the court concurred. The court made a declaration that the rules in failing to provide for a member of the Assembly to be able to exercise the right to have the Assembly vote on a motion of no confidence in the President were inconsistent with the Constitution. That's not the sort of decision which will win the heart of a ruling party. But the issues which arose in that case and in others for the Constitutional Court of South Africa, of that balance between legal, in that instance constitutional rights, and the will of a democratically elected parliament, are of the kind which arise in every parliamentary democracy, and I might say also in the state of Queensland. Cases like that require independence and courage, which are qualities which Justice Moseneke has exhibited throughout his life. He combines those qualities with learning and erudition to produce very fine judgments and speeches. And I can also tell you that there's a memoir coming in a few months, so look out for that, Macmillan Publisher. We're fortunate to hear one of his speeches tonight.
Let me again say thank you, Chief Justice. My wife and I, Cabo, are delighted to be in Brisbane. I've prepared a text. If you're long on the bench, you tend to write everything that runs through your brain. Bear with me. I'm going to work through the text in the hope that the Chief Justice will allow us or space rather to take questions and deliberate on matters that might interest you more. But I tend to write everything I do lately, and it must be a function of age and just being a lawyer for too long. So just bear with me. I'm going to run through the text as quickly as I can and get to and hope to be able to keep you awake by the end of all this. My wife, Cobb, and I are delighted to be in Brisbane as guests of the Supreme Court of Queensland. For that, we thank the Honourable Chief Justice Catherine Holmes. We owe our presence here also to Honourable Justice Glenn Martin, AM, who a good few years ago I met in Cape Town in a World Bar Association event. Since September 2015, Justice Martin spared no effort to get me here. I'm truly privileged to present this year's Supreme Court of Queensland oration as I join an illustrious list of past speakers. I propose to explore whether an appropriate balance could be struck between a robust form of constitutionalism and the democratic process. This I start by asking a few penetrating questions about my country. The South African democratic project is young, tentative, and just beyond adolescence. We live amidst more new and unsettled things than conventional and predictable orthodoxy. Often we leave the Chinese curse. Thank you. We do indeed live in interesting times. Every dawn seems to pose stringent questions about our polity. The questions are about our society in transition, about the usefulness and relevance of our divided history, about an unequal society and its proxies of race and class. We ask questions about governance, about the effectiveness of constitutionally ordained public institutions, about an economy that creates wealth but not jobs, about fair labor practices, and the opposite end of it, higher workplace productivity, about equitable access to social goods and services, like education, health, and housing, for vulnerable groups, about the efficient use of public resources, about public corruption, and indeed about private corruption and the deliberate distortion of market forces through anti-competitive practices. We ask a lot in our country about free expression and an open society, about the usefulness and potency of organized civil society. We ask about our rhinos and the environment, about the millions of idle and jobless youth who may imperil the democratic project, and we ask about everything else. There are clearly more questions than answers. These open, if not critical, conversations suggest that there are no holy cows or orthodoxies beyond public scrutiny. No boundaries are finite, no lines are incapable of being redrawn or even crossed. In many ways, we live in a society of unimaginable freedom and infinite possibilities. And the overarching constraint is whether our constitutional arrangements are well suited to realize the just society, the preamble of the Constitution envisions, and what our struggle for freedom was about. As though our debates don't throw up enough questions, in the past few years, persistent questions have sprung up about the legitimacy of our Constitution. The argument starts from the premise that the Constitution is an awful bargain, shaped by inept concessions during negotiations in 1993. The compromise, the argument goes, is characterized by two primary blemishes. The first, the will of the people does not find full voice within the constitutional arrangements. For that reason, the legislative and executive power in the hands of the parliamentary majority is said to be empty. Second, the constitutional constraints over the exercise of public power stand in the way of government to deliver on social equity. There is another way of saying that the Constitution has shielded the historic economic inequality from change and in turn has obstructed the effective economic participation or freedom of the majority. Excuse me. The subtext of this argument is that the will of the people on the project of transforming society is frustrated by the supremacy of the Constitution and the role courts fulfill in its compliance. These, of course, are intractable issues related to our constitutional arrangements. They demand difficult answers. In the time and the space at my disposal, I can only confront a few questions prompted by my judicial role. There are no obviously correct answers. For that reason, I do not intend to furnish close-ended answers, but rather recognize that there is a valuable public conversation in my country around these difficult matters. And I've chosen a few questions, and I will seek to answer each in that sequence. The core question is whether our constitutional arrangements permit an equitable balance between democratic will and constitutional supremacy. Is the people's voice heard, in other words? That inquiry in turn gives rise to a number of sub-questions. And they are, what is the constitutional value of democracy, if any? Why has our constitutional architecture opted for constitutional supremacy? And what is its purpose? Can a balance be struck between popular will and supremacy of the Constitution? And lastly, has our jurisprudence in the last 21 years found that equitable equilibrium between majoritarianism on the one end and constitutional supremacy on the other? Well, let's get down to answer these questions. When I was a young activist bent on destroying the monster of apartheid, we shouted many demands. However, I can't recall a demand of the struggle that resonated with my revolutionary zeal more than one person, one vote. It was and remains a primal demand that the will of the majority is in itself virtuous and must be given effect to. The right of each of us to participate in the democratic process is in effect a cluster of vital entitlements. These entitlements are emblematic of our equal worth and our equal citizenship. They include the right to form a political party, to participate in its activities, including to campaign for its causes. Each citizen has a right to free, fair and regular elections for any legislative body established, which includes the right to stand for public office and, if elected, to hold office. An exercise of these rights would result in representation in a parliament or in a provincial legislature or in a local government. Thus, to give content to these rights, our Constitution envisages a multi-party system of democratic government premised on universal adult suffrage and a national common voters' roll. A complaint, therefore, that the democratic will of the people is undermined merits serious attention, because if true, it strikes at the very heart of the constitutional arrangement of our democratic state. Before one probes whether this complaint is justified, let us look at what the Constitutional Court has said in dealing with the principle of the will of the majority required by our Constitution. And here I take refuge in what Albisex J. observed. The requirement of fair representation emphasizes that the Constitution does not envisage a mathematical form of democracy, where the winner takes all, until the next voting, counting exercise occurs. Rather, it contemplates a pluralistic democracy, where continuous respect is given to rights of all to be heard and their views considered. The dialogic nature of the deliberative democracy has its roots both in international democratic practice and indigenous African tradition. It was through dialogue and sensible accommodation on an inclusive and principled basis that the Constitution itself emerged. It would accordingly be perverse, says Albisex, to construe its terms in a way that belied or minimized the importance of a very inclusive process that led to its adoption and that sustains its legitimacy. The code ends. In a multi-party system of democratic government, one party state is excluded, as is a system of government in which a limited number of parties are entitled to compete for office. A multi-party democracy contemplates a political order in which it is permissible for different political parties to organize, promote their views through public debate and participate in free and fair elections. There can therefore be no doubt that the Constitution envisages that the will of the majority shall prevail, because our state is a democratic one. But that said, the Constitution poses a particular notion of democracy. Universal adult franchise is the primary building block in constituting legislative and executive powers. But this majoritarian primacy is subjected to the provisions of a supreme constitution. The Constitution makes plain that the Bill of Rights is the cornerstone of democracy in South Africa and that it enshrines the rights of all people in our country and affirms the democratic values of human dignity, equality, and freedom. In a firm injunction, the Constitution requires the state to respect, protect, promote, and fulfill the rights in the Bill of Rights, which in turn may be limited when it is justifiable to do so. So, the democratic ethos and practice are indispensable and constitutive of our constitutional state. The will of the majority, when expressed in some formal act through its duly appointed and elected representatives, must be given effect, and courts are bound to do so, provided the democratic will, if translated into law, policy or conduct bears a rational and legitimate purpose and has been passed by the procedures authorized by the Constitution. Simply put, valid laws bind everyone, but one cannot bypass the supremacy of the Constitution by merely asserting the parliamentary or executive will of the people. It must be a will expressed within the constraints of the Constitution. And this leads us to the next question, having settled the first. The will of the people is primary, provided it is crafted into law. We must then ask why our constitutional architecture has opted for constitutional supremacy. But before I traverse that question, I set out a brief excursion of the history of parliamentary sovereignty and constitutionalism very briefly in Europe, in Africa, and in our country. Now, the balance between the premium placed by most modern democracies on parliamentary democracy and the supremacy of the Constitution bears the stamp of historical experiences. In Europe, this balance was struck in the wake of the Second World War. On that continent, there's been a historically deep political hostility towards judges, and it was long assumed that constitutional supremacy, and as a concomitant, constitutional review by courts was incompatible with parliamentary governance, lest it led to a government of judges. However, in the wake of the Second World War, constitutional drafters recognized how unchecked legislative power, and in particular unchecked delegation, such as in Nazi Germany, in fascist Italy, and in Vichy France, had undermined both the democratic deliberative function of legislatures and emergent conceptions of constitutionally protected rights of individuals. So, the democratization of post-war Europe transformed the judicial basis of the European state. Modern constitutions typically proclaim a long list of human rights and establish mechanisms for defending the normative supremacy of the Constitution, stipulating procedure for how the Constitution may be amended. At the same time, however, the US-style judicial review was rejected by post-war constitutional drafters, as political elites remained hostile to sharing legislative functions with the judiciary. In contrast with the US judicial review, many European countries have limited review to specialized constitutional courts, an approach largely following on Kelsen, the philosopher's model of constitutional review. Very briefly, Kelsen recognized that the exercise of constitutional review would embroil the constitutional court in the legislative function, but nonetheless sought to distinguish between parliamentary legislative acts and what the constitutional courts ought to do. The former, Kelsen suggested, are positive legislators. They make law, freely subject only to the constraints of the Constitution. By way of contrast, constitutional court judges are negative legislators. Their legislative authority is limited to the annulment of statutes when they conflict with laws of the Constitution. Coming nearer home in sub-Saharan Africa, not unlike in South Africa from 1910, the constitutional arrangements were a product of the history of colonization of Africa. As the winds of change blew across Africa from 1958 onwards, triggered by the independence of Ghana, the newly adopted constitutions mirrored those of departing colonial powers. That explains why Francophone countries were characterized by constitutional councils. Along the French model, and Anglophone countries had parliamentary sovereignty as a preferred model. But virtually all sub-Saharan post-colonial jurisdictions were characterized by the absence of a vibrant electorate, of an exacting civil society. They had no organized labor movement, nor did they have a free and independent press. And they did not, as we know, have a supreme constitution that was justiciable, and therefore never had effective model of judicial review. None of these guarantees were to be found, therefore, in African post-colonial arrangements that sought to mimic the Westminster style of governance without the safeguards of liberty provided by the English common law. Sadly, those ineffectual post-colonial polities in Africa displayed undemocratic tendencies that readily provided fertile ground for open-ended abuse of executive, fiscal, and legislative power. That indeed resulted in wholesale denigration of democratic practice, pervasive pillaging of the fiscus, and corruption. The violation of fundamental rights became endemic, matched only by overdependence on the auctioning of raw materials and elite self-enrichment at the expense of grassroots economic development. And I say all this not unmindful of the deleterious role of neocolonialism that sponsored civil wars in order to mask the plunder of national resources and to expand foreign markets onto the African continent. There are indeed glimmers of hope for our continent as we see the steady but slow emergence of democratic constitutionalism and improved inclusive economic activity and rural development in a number of countries on the African continent. The continent is well on its way to banishing Afro-pessimism of yesteryears and maintaining high levels of economic growth. Turning inward, it has to be said that our adoption of constitutional supremacy was similarly influenced by our history. Under apartheid, Parliament enjoyed supremacy, and no constitution or Bill of Rights provided any fetter on its legislative powers. Oppressive laws passed by Parliament could, for most part, not be changed in the courts. They could not be challenged, I beg your pardon, in the courts. The apartheid regime was sustained by lack of accountability and the construct of or constraints on parliamentary sovereignty. Take, for instance, Parliament's effort in pursuit of apartheid policy to disenfranchise any voter who was not classified white. And the classical cases are known to those who have followed South African jurisprudence in Harris, as Minister of Interior. There, the appellate division declared new legislation invalid on procedural grounds, only for Parliament in 10 to pass the High Court of Parliament Act, which allowed Parliament itself to set aside decisions in which the appellate division declared legislation to be invalid. So Parliament was truly sovereign. It is so that, as we recall the past, we remember very well, we who are South African, that parliamentary sovereignty would reinstall Parliament as the sole arbiter of the rationality of measures they pass. The will of the majority in Parliament would be unrestrained. The majority would have a license to oppress. Socioeconomic rights, which are now justiciable and are a significant bulwark in favor of the vulnerable workers, the vulnerable worker rights, which are now constitutionally entrenched, and other fundamental rights would be enjoyed only at the pleasure of Parliament. But as we have seen, that is the constitutional option through which apartheid, Nazism, fascism, post-colonial Africa blossomed. We will have none of that. It must be emphatically added that the people on the ground, and not the elite, were the foremost victims of apartheid. They bore the full burden of unjust laws. Barring its minority electorate, Parliament was accountable to itself and to nobody else. Its legislative deeds were totally immune to judicial review, and its executive and administrative acts were subject only to benign judicial scrutiny. Our founding mothers and fathers, well aware of this deleterious impact of parliamentary sovereignty, made a different choice. They sought to bring to life a democratic state under the sway of a supreme constitution and chose to entrench fundamental protections that have and a binding normative scheme. Of course, there are inherent tensions in our constitutional architecture, which I've just described. And I tend now to look at how best to balance what appears to be two antithetical constructs within one constitutional state. There can be no question that our founding fathers and mothers made an unambiguous election to bring into being a constitutional state. However, emerging constitutional skeptics, right in South Africa itself, call to question the wisdom of such an all-pervading and imperious supreme law. As we have seen, they decry the potential of constitutional review of, in the language of the Constitution, all law or conduct of the legislature or the executive by the judiciary, and in that way subvert the will of the majority they represent. These critics, however, should be reminded that as a reaction to our hellish apartheid past, the concepts and values of constitutional state and of an egalitarian society are deeply foundational to the creation of the new order that came out of our long struggle. In fact, the detailed enumeration and description in section 36(1) of the Constitution sets out the criteria for limitation of rights, and it's quite a strict criteria. So we have moved, therefore, from a past noted by much which was arbitrary and unequal in the operation of the law to a present and a future where the state action and private action must be capable of being rationally justified. As we all know, as lawyers, arbitrariness by its very nature is dissonant with those core concepts of our new constitutional order. Law or conduct that is arbitrary or unjustifiably limits or entrenches on rights or in some other manner is inconsistent with the Constitution is invalid at the behest of the doctrine of constitutional supremacy. Having said all that, it must be considered that if there is a danger in parliamentary sovereignty, there is also a danger in constitutional supremacy. And the contemporary attacks on the Constitutional Court as undermining the popular will have traction precisely because they are rooted in a legitimate fear. A tension clearly exists between democratic theory and constitutional supremacy. This is not a dilemma peculiar to our shores. It is perhaps as endemic as there are constitutional democracies. Constitutional law scholars have called this conundrum the counter-majoritarian dilemma. When the courts, through the exercise of judicial review, strike down legislation, declaring it, for instance, constitutionally invalid, they override the will of the prevailing majority, as expressed by Parliament. In short, the supremacy of the Constitution and its policy by the courts, through judicial review, places unelected public officials, namely judges, with the power to nullify acts of elected public officials, and thus seem to undermine the fundamental doctrine of democracy. I want to suggest that constitutional supremacy and democracy are not, however, necessarily irreconcilable or at loggerheads. A synthesis of the two indeed undergirds all modern constitutional democracies. Without devaluing the institutions constituent of representative democracy, constitutionalism holds that certain essential features of the polity, most importantly, certain fundamental rights and institutional guarantees protecting them, may not be amended or destroyed by a majority government. In other words, the Constitution sets a normative constraint on majoritarian politics. In their preservation are entrusted to the judiciary. Judicial review then, seen in this way, is a necessary mechanism for preserving the Constitution, for guaranteeing fundamental rights, enforcing the limits of the Constitution itself imposes on governmental power. On the one hand, constitutional democracy recognizes the principle that government is based on the legitimate will and consent of the majority of the governed. And yet, on the other hand, constitutional democracy places limit on this principle by entering into this pact where the majority on their own limit their own power. On this view, democracy should not be simply equated with majority rule. It should no longer be understood as a political community governed by the principle of parliamentary sovereignty, but rather one governed by the principle of supremacy. And there are several good reasons for this kind of balance. The first, it may be correctly posited that when we in South Africa adopted the Constitution, we entered into an original contract. As Herschel, that great constitutional lawyer, puts it, members of the polity or its constituent assembly provide themselves with precautions or pre-commitments against their own imperfections or harmful future desires, and bind themselves to the initial agreement on the basic rules and rights that specify their sovereignty. In other words, a pact that says, I will not oppress you, even if I want to. In other words, for us, democracy is more than a mathematical game. It's a veritable vehicle for realization of a cluster of these foundational values and achievement of the ideal society we want. Second, some commentators, in justifying the balance I've been suggesting, suggest that constitutional supremacy and specifically judicial review by independent constitutional courts may actually further democratic ends by facilitating political representation and participation by minorities that are otherwise excluded from policy making by the majority. The third consideration which has been advanced for the kind of balance we sought to strike in South Africa is influenced by institutional economics. The argument is that economic development and investment require as prerequisites predictable laws and a legal regime that ensures the protection of private property rights. So the constitutionalization of rights increases investor confidence and allows for a more consistent, predictable, and efficient enforcement of contracts. There's a fourth consideration that's often introduced, and that relates to separation of powers, which suggests that in any event there are checks and balances on how far the judiciary may go. And in our case in particular, that power of review is spread amongst a number of bodies: the Public Protector, the Human Rights Commission, the Commission for the Promotion and Protection of Rights and Cultural Rights, the Commission on Gender Equality, the Auditor General, the Electoral Commission. So the suggestion is that public power is spread. As I conclude here, it must be added that a claim that constitutional amounts only to limiting government power, I want to suggest, is misleading and potentially dangerous. And that brings me to the last question that I would like to deal with. As I come to the end, I must, though, briefly evaluate whether our jurisprudence has struck an appropriate balance between majoritarianism and constitutional supremacy. It's a simple way of saying, in practice, what did our courts actually do? Let me at the outset say that I think that our courts, and in particular the Constitutional Court, has done a reasonable effort in striking the appropriate balance, elusive as it is. A few examples should suffice before I sit down. A good starting point would be the State versus Makwanyane. The Constitutional Court was required to determine the constitutionality of the death penalty, particularly for murder. Chaskoson P. I had earlier today that in this state, the death penalty was abolished a long time ago. And that made me quite happy, Chief Justice. Chaskoson P. accepted that the majority of South Africans believed that the death penalty ought to be imposed in extreme cases of murder. There's an admission that if you had a poll in South Africa now, those who want death penalty would win, or referendum, they would win. So it was proper for the judgment to acknowledge that. He acknowledged that public opinion may hold some degree of relevance, but stated that in itself it is no replacement for the duty vested in the judiciary to interpret the Constitution and to uphold its provisions without fear or favor. As he explained, if in his words, if public opinion were to be decisive, there would be no need for constitutional adjudication. Of course, Makwanyane provoked an outcry throughout our country, people baying for the blood of others. But the court was faithful to its judicial obligations under the supreme law. Popular sentiment and constitutional principles, and the court weighed in favor of constitutional principles. I've been a member of the Constitutional Court for nearly 15 years, and I accept that I'm less than dispassionate about the track record of that inimitable court. But I want to suggest to you that our court is fearlessly pronounced on vital public and private disputes. And in so doing, we have crafted a jurisprudence we certainly are proud of. The court has pronounced on the right of access to housing. It has repeatedly ordered government to find and furnish alternative accommodation as homeless people are evicted. We have intervened to ensure that vulnerable people have access to social grants, including immigrants. We have ordered government to provide antiretroviral medication to mothers afflicted by HIV/AIDS in order to stunt transmission from mother to child. The court has not hesitated to pronounce on a whole range of procedural and substantive rules of criminal justice system, in that way overhauling it and introducing fresh air of justice in that terrain of the law. The court has often mediated between state organs, drawing clear lines of authority amongst and between them. Our equality jurisprudence is a matter of great pride and world renown. The court has unhesitatingly banished discrimination and exclusion on virtually every conceivable ground. On occasion, and perhaps not as often as it should be, it has refashioned and adapted the common law that we inherited from England as well as from the Dutch, and indigenous law in line with our constitutional ethos. When appropriate, the court has invoked the indigenous values of Ubuntu and infused them into our law in ways most beneficial. And as required by the Constitution, the court has tested many acts of Parliament, both old order and new order legislation, and administrative decisions for constitutional compliance. Lately, there's been increased contestation between the ruling and opposition parties and within the National Assembly, requiring our courts to pronounce on how Parliament accomplishes its business, short of throwing fists around. The disputes included whether Parliament had allowed the constitutionally required space for an opposition party to bring a motion of no confidence in the President, a case the Chief Justice referred to in a moment, whether legislation which permits the eviction of a member for expressing a view in Parliament passes constitutional muster. Even more recently, our court was called to test whether Parliament had properly held the executive, and the President in particular, to account on his non-compliance with remedial action set by the public protector. In another corridor, the court had to examine the probity of massive public tenders or the anti-competitive conduct of large corporations. It is so that not all court watchers think that we've done a good job all the time. In respect of socioeconomic rights, some have made out a compelling case that the court has been excessively differential to the political branch or the executive branch of government. This deference, it is argued, is apparent from the court's refusal to entertain the minimum core approach to enforcement of socioeconomic rights, as well as its refusal to exercise supervisory jurisdiction more frequently than it has. My personal take is that socioeconomic rights jurisprudence in our country is in many ways embryonic. It can hardly be said that the court lacks the commitment to protect the most vulnerable amongst us, whose interests in access to housing, to shelter, to education, to healthcare is vital. And we have rulings on all of these matters, as you know. As evictions increase and other economic pressures befall the vulnerable in society, the court has seen an increase in socioeconomic rights claims. And about that, we are delighted. Virtually all of them have come on the side of those who need justice most. I have no doubt that opportunities will arise to help deepen our socioeconomic rights jurisprudence in order to come to the rescue of the most vulnerable amongst us even more so. The court has not been slow in taking cue from international law, in taking seriously our international obligations, including on issues of immigration law, and where appropriate, our court has looked to foreign law, including jurisprudence from this very country, for guidance. Our judgments, for those who have cared to look at them, tend to be replete with comparative law because we feel we are part of the global legal village. Lastly, I do think it is an error to characterize the relationship between the court and the branch of government as oppositional or inimical. Let me start off by reminding all of us that the government, and so too the ruling party, has always made it publicly known that it respects the rule of law, that it is committed to upholding the Constitution, and that it would give effect to court's orders, and that it is a partner with courts to realize the high ambitions of our Constitution. They've lost most cases, for sure, but each time they've lost, they've reassured us that they will comply with our orders. The government has, by and large, done so. And in my experience, where court orders have not been implemented, it has been as a result of some or other administrative ineptness, and not as a result of outright or open recalcitrance. The function of the Constitutional Court, albeit counter-majoritarian in the view of some, is ultimately supportive of democracy. It upholds and protects and ensures democratic protects and protects both the minority and majority rights under the beneficence of our constitutional arrangements. And from experience, judicial officers who grace our courts are emphatically patriotic and loyal to the Constitution. and the will of the people as encrusted in law. And they must continue to ensure that the bench is not only representative of our demographics, but also competent and well cut for the task. After all, we are a transitional society which requires a strong and competent judiciary. And that combination in time will enhance the legitimacy and the effectiveness of our judiciary. That judges sometimes hold against or other times for the government, frankly tells us nothing about the judge's commitment or the lack of it, the democratic project of our country, as some sometimes suggest. That they get the law wrong sometimes only reminds us that they are human and explains why we have appellate safeguards. There's simply no place for wanton attacks on judges, suggesting that they are fostering some arcane, if not dishonest, agenda. An average judge approaches her work with utmost industry and sincerity, alive to the grave responsibility she bears in the national project to create a just and a better life for all, particularly in our country. And as retired 3 weeks ago, Chief Justice, I was humbled by the wide and reverent recognition by the broader society of the role of our court has played in deepening democratic practice in the last 21 years. They came out in all their halts on social media and clocked it for 4 days, with the court trending, South Africans expressing their gratitude for the role of the court in the last 20 years. And these outpourings of compliments suggested that the court's jurisprudence has found the rich equilibrium between robust constitutionalism and the democratic practice that our Constitution so admirably imposes. Thank you for listening, and may God bless.
Thank you, Deputy Chief Moseneke, for that address. It's my privilege as Chair of the Supreme Court Library Committee to move the vote of thanks. It, as is sometimes the case, appears to be a superfluous role given your immediate reaction to the address, but I will do it anyway. First, I should thank Deputy Chief Justice Moseneke, if I may still call you that, for accepting Justice Martin's invitation to speak. And I should thank Justice Martin for his pivotal role in securing the attendance of our Speaker. Earlier this afternoon, Deputy Chief Moseneke was querying the validity of the contract he formed with Justice Martin, because very soon after it was formed, word of it leaked out. And as a result, his schedule in Australia became a remarkably demanding one, such that reading his itinerary made me tired just reading it. So I thank Justice Martin for that. To address the tensions between parliamentary sovereignty and constitutional supremacy is really a big ask. It is to take on a fundamental topic. And as we heard from the Chief Justice's introduction, it is really difficult to envisage a Speaker who could have the qualifications of our Speaker tonight to address that topic. We have in Australia, it's easy to acknowledge, a much more comfortable existence, and our judges have had a much more comfortable existence than that of our Speaker. Nevertheless, many of the topics addressed tonight resonate here. In particular, one that sticks in my mind is a statement made with great authority that judges, or at least judges from whom appeals may lie are human. So I personally thank you for that. But we have heard a very illuminating and educational address. It is really hard for me to understand how I have learned so much in what is actually under an hour from when the address started. The themes have been universal, really, an analysis of those tensions from the point of view of economics, history, not just South African history, but world history, the geography, and constitutional theory. So I wish to ask you all once more to express your appreciation for this wonderful address. I have one more pleasant task to do, which is to hand Deputy Chief Justice a gift, which is a very small token of our esteem, and I guarantee it's a light gift for you to carry on your travels. Thank you, sir.
Thank you so much.
Now, it's my pleasure to invite you all to join us for refreshments in the foyer outside, where you may, if you wish, take up Deputy Chief Justice Mosenike's invitation to ask him questions. Thank you.